Okay, so this is the second part. We are in Chapter 15 of our employment law. This is labor law, page 881. Section is Part 3, Regulation of the Employment Environment. The Taft and Hartley Act of 1947. With the enactment of the NLRA and subsequent gains made in the unionism, the Taft and Hartley Act of 1947 was enacted as an amendment to the NLRA to curb excesses by unions. Most importantly, the Taft-Hartley Act changed the policies of the NLRA. No longer were all employers legislatively determined to be frustrating the organizational rights of their employees. Congress recognized that unions had grown so strong and powerful over the years that their activities required federal regulation. As such, unions were to have certain limitations placed on their activities. Congress wanted employers, employees, and labor unions to recognize one another's legitimate rights and made the rights of all three subordinate to the public's health, safety, and interests. Section 7 was rewritten. Section 7 was rewritten to recognize the right of an employee to refrain from concerted activity, including union activity, like Section 8 of the Wagner Act, which enumerates unfair labor practices that could be committed by employees. Section 8 of the Taft-Hartley Act spells out 6 unfair labor practices that could be committed by an organized labor. See Exhibit 1510, Union Unfair Labor Practices, thereby bringing unions under the regulation of the federal law. Under this section, it is an unfair labor practice for unions to restrain or coerce employees in the exercise of their rights or employers in the selection of their representatives for collective bargaining. 2, cause an employer to discriminate against an employee. Whoops. I'm not going to take it out. Sorry, everybody. This is live lecture. Things like that happen. All right. Number 3, refuse to bargain with an employer. Engage in jurisdictional or secondary boycotts. Charge excess or discriminatory initiation fees or dues. Cause an employer to pay for goods or services that are not provided. In an interesting case from 2014, the NLRB refused to find social media statements made to employees who worked during a strike to be violations of the law. On the union's Facebook page, union members verbally and physically threatened employees who refused to participate in the strike. One union member even posted that he found the addresses of the members who crossed the line, and another commented, "Can we bring Molotov cocktails?" One of the employees filed an unfair labor practice charging the union was obligated to disavow such statements because they coerced and restrained employees in the exercise of their right to engage in concerted activity and crossing the picket line. The NLRB determined that the comments were not threats that violated the law, and the union was not responsible for them because the members making them were not agents of the union. Before closed shops, where the employee must become a member of the union in order to obtain a job, were outlawed by the Taft-Hartley Acts, which states enacted right-to-work laws. See Exhibit 1511, right-to-work states. This was done in response to the closed shops by unions to control dissenters by severing their union membership, without which they could not work in a closed shop. The NLRA permits states to have right-to-work laws, and as of 2017, 28 of them do. In a right-to-work state, employment cannot be conditioned on union membership. Despite some employees' non-participation in the union, and thus they're not being required to pay union dues, the union must still represent these employees as part of the bargaining unit. If a state is not a right-to-work state, the union and the employer, moving again, yes, unsightly coffee scene, may have as a part of their collective bargaining agreement, union security device, a provision for a union shop. This provision, called the Union Shop Clause, requires the employers to have all members or potential members of the bargaining union agree that they will join the union within a certain amount of time, not less than 30 days after becoming employed. All right, so that's our Summary of the Taft-Hartley Act, the conclusion of employment laws, excerpt on it.